The 1951 Convention relating to the status of refugees was established and approved at a special UN conference in 1951, and it sought to address the need to pursue a global solution to the issue of refugees and asylum seekers. It relates to Area of Study 3, ethical issues, because it's one example of an international law treaty that has been created to address the challenge of people movement. So what is it, and what does it seek to achieve? It seeks to protect the rights of a person who is seeking asylum with a genuine fear of persecution. In doing this, it tries to bring states together in a binding way, hence it's an example of international law. And so in great detail it outlines the responsibilities of ratified states and the rights of the people who might arrive in states who have signed the treaty. More specifically, it defines who a refugee is and the rights of these people once they're granted asylum, as well as the state's responsibilities. It also lays out the responsibilities of UNHCR, and these include exercising the functions and features of the treaty in cooperation with ratified states who are expected to work with UNHCR. So the treaty defines who a refugee can be, and the detailed definition reads like this, as seen in Article 1 of the Convention. Quote, a person who, owing to a well-founded fear of being persecuted for reasons of race, religion, nationality, membership of a particular social group or political opinion, is outside the country of his nationality and is unable, or owing to such fear, unwilling to avail himself of the protection of that country. Or who, not having a nationality and being outside of the country of their former residence, as a result is unable, or owing to such a fear, unwilling to return to it. So the key idea here is a well-founded fear of being persecuted in their home country. The convention was initially designed to help settle refugees following World War II, in particular pertaining to European refugees who feared persecution before 1951. Some of the features, as previously outlined, are that it defines who a refugee is. It also outlines some of their rights, such as that refugees have access to courts in the countries in which they reside and non-discrimination when using these courts. It outlines some specific social rights, such as receiving free public elementary education, having the freedom to practice their own religion, and having access to the same level of healthcare as those in the country where they are seeking asylum. The Convention also specifically outlines who cannot apply to be a refugee, and this includes those who have been committed for war crimes, those who have committed crimes against humanity, and other serious non-political crimes. With regards to who has signed the treaty, 145 states have signed and ratified the convention, and this includes Australia and New Zealand. 2 states who haven't signed are USA and Indonesia. And we mention Indonesia because we look in detail at Indonesia in Area of Study 2. One reason states don't sign is in order to maintain their own power and decision making over who can and cannot come into their country. This image depicts that this is a relatively successful treaty in terms of signatories and ratified states. 145 is a large number, but the 2 states we would look at comparing would be Indonesia, who has not signed and ratified, versus Australia, who has signed and ratified. So what are the obligations of these states? Well, one is to recognise that UNHCR is responsible for exercising the Convention's functions, but states are obliged to work with UNHCR. And these states are obligated to not penalise refugees because of the way they've entered a state. Secondly, to recognise that seeking asylum can sometimes require the breach of immigration rules. States are obliged to accept certain safeguards against the expulsion of refugees to make sure refugees are not expelled or kicked out of a state. And lastly, the principle of non-refoulement, meaning no one shall return a refugee against their will back to a state where they may fear persecution or where their life or freedom is challenged. There are some problems with this particular convention. One of them is that it was only designed to apply to people applying for refugee status or fleeing Europe, particularly from World War II. And secondly, it was only really concerned with people facing persecution prior to 1951. So there were specific geographic and time limitations that refugees at that time, where those refugees were coming from. Of course, another challenge or limitation of this treaty is that if we hadn't made changes to it, people fearing persecution in a post-2000 world would not have been able to use the Refugee Convention to apply for asylum, to apply for protection. Another challenge is that not all states have to sign it. Therefore, states that haven't signed don't have any obligations towards the treaty and do not need to recognise refugees who may be seeking protection. The decision not to ratify the convention is largely due to its binding nature. This means that the sovereignty of the state is undermined, as decision-making and authority over migration issues around refugees, might not necessarily, the convention rules might not necessarily be in the interests of the state, yet the state is obliged to live by the certain conditions as defined in the convention. The convention relates to our course in a number of ways. Firstly, in terms of international law, it's an example of international law as it suggests and aims to influence the behaviours and outcomes of states in order to set up some sort of norms that states should follow. It relates to globalisation because the convention, because the refugees and asylum seekers break down the borders between states as they move back and forth between states and seek and pursue asylum in another state that isn't their own. Further, we need to recognise that people smuggling today has intensified and is the third most profitable illegal trade on earth. It also closely links to the issue of sovereignty. When states ratify the convention, some of their sovereignty is given up because they agree to enforce the regulations and laws as found under the convention. Lastly, the treaty could be an example of pragmatism. So when states sign the convention, they're taking a pragmatic approach in order to address the issue of people movement in a practical way in collaboration with other states who may have signed the treaty.